Big welcome to you all, our esteemed viewers. Today is the 28th of May 2023, and we are here in Bali to discuss a topic on occupiers liability and product liability. Tonight, we have 4 panelists who will be discussing exhaustively on all those topics that are around the law of tort. My name is Owori Zakaria Onyango, and I'll be the host or the moderator of this show. So, ladies and gentlemen, you're welcome.
Thank you.
I will start by introducing.
Thank you very much. I'm most humbled to be in this show. My name is Bradley Martin. I am going to be a panelist for today, and I would like to hope that whatever I share will be of a fruitful discussion with you all.
Thank you. My name is Mukisha Kevin, and I'm one of the garage panelists. I'm so much happy and privileged to have this opportunity to talk about things that relate to law. So I'm so much happy and privileged and humbled at the same time that I have an opportunity to share something that is attached to the law, to change someone and understand more about the law.
Thank you very much, moderator. My name is Winfred Edred Kayange, and today I'm blessed to be one of the panelists that are going to be discussing national matters this afternoon. And I believe that whatever we are going to share shall be a help to someone out there and shall answer a question or two. Thank you.
My name is Masereka Gregory, one of the speakers tonight, and I'm happy to be here speaking about law and exhausting law to our fellow viewers, as well as addressing their minds about the concept of law on occupiers liability and product liability. I'm so much humbled to be here. Thank you.
Okay, thank you very much. Ladies and gentlemen, allow me to re-echo that today we will be discussing occupiers liability and liability for defective products. As you've seen, all our panelists are outspoken and they have enough knowledge to admit to you tonight. Allow me, ladies and gentlemen, to commence by introducing the topic, and that will be done by one of the panelists. Ladies and gentlemen, so what is occupiers liability?
Basically, occupiers liability is a branch of the law of tort. Remember, for the issue of tort, we are dealing with civil wrongs that people are facing. What is a civil wrong? A civil wrong is a wrong that is committed on someone. It is not criminal per se, but rather it is something that is done to you because someone had a duty to provide unto you, but rather decided to neglect this duty. It results into a tort. So particularly for occupiers liability, we are talking about the responsibility someone is having unto you, the person which has a duty of care to take in case you happen to get into this person's property. For occupiers liability, basically, we are going to begin by understanding who is an occupier. An occupier is someone who owns land. It may be someone who has the land, the issue of a lease. It may be someone who has been given responsibility to take care of this particular property. It may be land, like I said, it may be a vehicle, it may be a vessel, and whatsoever. So that is basically the definition or an example.
Maybe to add more on this, occupiers liability refers to the liability that arises by some person owning a property to the people who come. That is the duty of care that is owed by that person to to the people who have come onto his or her land. Once it is breached, then that's when we can say that there has been what? Occupiers liability. Furthermore, in the case of Wheat versus Elacon and Company Limited, they attempted to define who an occupier is, and they say that it is any person who exercises a higher degree on the premises. So, if you have a higher degree of a certain premise, then you definitely qualify to be an occupier. So, as my brother, as my co-speaker of the night has echoed, you can happen to be an occupier of maybe be it a house or be it a car. You get, on your way you happen to give a person a lift, there you happen to have higher degree over that vehicle. So if anything happens to that person you've given a lift to in that vehicle, then liability will arise.
Okay, like addressing my mind to occupiers liability. In particular, I'm talking about legal recourse of a claimant trying to sue or take action against a person who owns a premise, and as a result of an injury inflicted onto that claimant simply because maybe the owner or the person with authority or who has control, who is taking control over that premise, failed to exercise a duty of care on those people who accessed or who lawfully accessed the premises with a purpose. You must be with a purpose in order for you to be a claimant or to have a legal recourse as far as occupiers liability is concerned.
Maybe just to chip in, help our viewers understand what a duty of care is. Because from what we've all been discussing, an occupier is someone who owes a duty of care to another by virtue of occupying certain premises. Okay? So my question is, can you help these people out there understand what a duty of care is?
We're talking about legal authority. I will refer to the Occupiers Liability Act, that is 1957 of England, which imposes a duty of care to an occupier or a person who has authority to make sure that a premise is safe from any harm, from anything that will injure lawful occupants or visitors. So, duty of care is simply making sure that you're taking a responsibility to ensure that nothing happens on another person or no injury happens. You're making sure that there is safety. That's duty of care. For example, I'll give you a scenario where my neighbor dug a ditch and there were children around the neighborhood. So he had to gazette or he had to put a warning that there is a ditch within these premises. So he is simply exercising what we call duty of care, so that those little children don't fall victims of such a kind, to avoid injuries or damages. Thank you.
Okay.
Maybe the moderator to chip in about the duty of care. Duty of care, in a nutshell, duty of care refers to the restriction of the defendant's freedom. Much as the defendant has freedom over his premises or over anything, he has got to restrict the freedom in order to cater for somebody. You get? In other words, there is another person who requires you to take care of them that you must make sure they are not harmed or damaged, much as you also enjoy your freedom. You get? So the duty of care just simply means a restriction of the defendant's freedom. You enjoy your freedom, but on your land, but then Kevin has come onto your land, definitely you have to take care of him. On top of your freedom that you've got on your land, you've also have got to make sure that Kevin has come to my land and he has left the way he has come. That is the duty of care. In other words, you're restricted from the enjoyment of your freedom. You cannot purport to say that I'm at home, he has come. But he's a visitor. You get? He's a visitor, he has come and is entitled to
Who is not
that care.
Who is not even aware of the poor state of the premises, perhaps.
Yeah.
So to ensure that there is a duty of care to ensure that he doesn't get any injury.
So just to wrap it up, the way you will feel if you visited somebody, it is the way that person onto your land should feel. Yeah.
Before you wrap it up, my co-speakers have tried to come in and explain about duty of care. But then if someone poses to you a question about duty of care, I believe we have to connect these towards the duty and the care. Okay? And at this time, we are talking about occupiers' liability. So to help someone out there understand about this duty of care, that is a responsibility that no one is going to wake up in the morning and tell you, you are supposed to do this. You as a person, by virtue of who you are, it bestows that responsibility upon you to do that particular thing. It comes in like it has some sort of naturality that I can say I can attach to it, and it comes in by virtue of who you are and the responsibility you have to the other party. Precisely.
Well, thank you very much, all our panelists. I think they are all vividly espoused what a duty of care is. And Comrade Gregory was submitting, and I managed to pick out something from his submission. He talked about a visitor. Who is a visitor on a premise, or who is a visitor on land?
It should be a lawful visitor in the first instance. There are certain provisions or conditions you have to meet for you to be a lawful visitor. First, I'll talk about under statutory provisions. You have certain visitors who are lawfully authorized to access your premises under statutory laws. For example, we talk about these employees of National Water and Storage Corporation. When they are under their operations, they are entitled, or they have that authority or that permission to access your land. So you also have a duty of care as the owner or as an occupier to make sure that you take care of them not to have any injury that will maybe perhaps damage them, and you are now sued for negligence.
Well, on the concept of being a visitor on land, I would still add on to what you said. Being a visitor on land by statutory provision, we basically know a statutory provision, these are laws that are set for us to abide by. So the law may provide that. An instance he has given is people of National Water. They could be coming to your place to repair your tap. Someone who works with the electricians would be coming to help you electrify, or maybe they are coming to plant a pole of electricity at your place. The law provides that these people, at certain times, they may give you notice to come in to your land. So when this notice is given to you, they become visitors on your land by virtue of statutory laws. Then also they are visitors by implied terms. Visitors by implied terms. These are people who occupy your land. As much as you have not invited them, you'll always find them. You'll always find them being visitors on your land, because it is something that just basically implied. For example, I can take an example of door-to-door sales. When someone brings you property, like goods, when someone is selling you goods, you can be delivering you goods. You may certain times not necessarily have invited him. Say for example, people of post office, they're delivering to you an email or a newspaper. Then these who do the delivery of newspapers to your place. By implied terms, when they come to deliver that particular item or commodity, they qualify to be visitors by implied terms. Then they are visitors by express terms. So visitors by express terms, these are people who come to your place by virtue of you inviting them. For example, you have a wedding ceremony, you invite your colleagues and you say, Mr. Gregory Masereka, I am inviting you for the wedding party of my daughter. When you invite these people into your place, you may say it is going to be at the gardens. So when someone comes to your place and he comes as a visitor to attend the wedding party of your particular daughter, you're going to set a time for them. So for example, you say it is going to take place between 10 a.m. to midnight. So during that period, they become visitors. As much as they enter your land, they always come with limitations.
And this reminds me of one thing, is that a lawful visitor can as well be a trespasser.
Yes,
to some extent.
Yes.
Maybe, comrade, can you show us the extent to which a lawful visitor can be a trespasser?
This comes in like he gave us an example of a party. You have invited me, I have a particular purpose I'm doing there, I'm attending the party. But in the due course, I really exceed the time we agreed upon on staying within those premises. So maybe I move around, I exceed where the boundaries, so I get an injury from there. I may not have any legal recourse towards that owner of that premise.
And to add on, lawful visitors have these laws governing their visits and hence branding them or qualifying them to be lawful visitors. The moment someone steps outside their boundaries or someone breaks the laws or the rules governing them as visitors, they automatically become trespassers. If I invite you for a party, it is maybe from 8 up to around 2, and then by 2 the party is closed and you remain in my premises. I mean, what are you doing there? You are trespassing because the purpose for which you came there is done. Then also, when you change purpose for being in my premises, I've invited you for a party, but then you come for that party, and then you also create your cocoon of maybe people in a certain corner to booze. You become a trespasser because you have moved outside the laws governing you on my premises.
Yeah, maybe more to add something on the visitor. When you talk about a visitor, what comes into your mind must be permission. Yeah, so a visitor, to be qualified to be a visitor, he has all kinds of permissions to access the premise. And now this also will drive me to what my colleagues have been talking about. We have a person with an express permission. Express permission, it's literally interpreted as something in writing. I invite you to my place or to my land, onto my land, but by virtue of the document. Yeah. So if a person has come to my land by virtue of my invitation that has been expressed, like I've said it either in writing or verbally, then once it's harmed onto my premises, I'm liable, or you're liable if you invited that person onto your land. That is, if he keeps in the course of what has brought him onto the land. Then an implied permission. This will drive me to rescue situations. I'm somewhere and my house is burning. You get, my house is burning. So for a purpose of rescuing some person, the person can come onto my land to rescue. Definitely you acquire what you call implied permission. I cannot question you, why are you on my land when my house is burning?
Why breaking my law?
You get? Probably you've broken it to rescue a life. You get? Then the statutory permission. This is, as my colleagues have been saying it, airing it out, it is more of law. Legally into your land. Probably I could be a bailiff. I'm under an order. I've been sent to your premise maybe to execute something. Then I'm more or less of a statutory visitor to that land. Then maybe a police person. You cannot say that the police has showed you a arrest warrant and you think that is an invitation. No, that is an identification. But he has got what you call statutory permission. Once you've been spotted to be a criminal, then you cannot stop police from acquiring the premises. They will get you at whatever cost without them having any documentation. So what they show you once they have come to your premises, it is just an identification. Identify themselves as police, but from the onset, they have got a statutory permission to your premises.
Okay. Thank you very much. I am actually enjoying the dialogue. I want to move straight to find out from you what are some of the preliminaries that qualify an action in occupiers liability. Like, for instance, I am a plaintiff and I want to sue. What are some of those requisite elements I must prove in order for my action to succeed in court?
Okay, to perhaps make an attempt to your question. As a plaintiff, I must be in position to show that there was a duty of care.
True.
Yeah.
Owed to the
Owed to me.
occupier.
By the defendant. Then that duty of care was breached. And it is that breach that has caused harm, has caused damage. You get? So as a plaintiff, if I can perhaps prove the three, that there was a duty of care, that duty of care was breached by the defendant, and then through that breach that I'm suffering, the damage that I'm suffering right now, then I can purportedly say I have a cause of action against the defendant.
Okay, thank you. So maybe Comrade Gregory, what could be the legal framework governing occupiers liability as a principle of law of torts in Uganda?
Well, the concept of law of liability, of occupiers liability in Uganda is underway. It is under its evolution, since we don't have any specific law or statute that governs occupiers liability. Occupiers liability is multi-dimensional practice encompassing elements like statutory laws. Talk about England. We talk about England common law and criminal liability. So, since you don't have that statute, that specific statute that really regulates occupiers liability, there are legal bodies or legal institutions that are coming out to advocate or bring out necessary views to make sure that there is occupiers liability legislation. For example, I'll give you a case in point. The Uganda Legal Reform Commission, which is a member of the justice law and other sector in Uganda, it had a workshop, that is 2018, which was held to come up with proposals on the occupiers liability legislation to ensure regulations of protecting the lawful visitors who come into someone's premises to be free from injuries, and that is under we are still proposing on such kind of law. But basically, we are basing on the common law principles and statutory law principles. For example, the Occupiers Liability Act of 1957.
Okay, thank you very much. Maybe basing on the established principle of law that there is a presumption of innocence in every action, I want to pose this question to you also. What are some of the defenses that can be available for one who is sued under occupiers liability? What are some of those defenses they can raise in order to have themselves acquitted in court?
Well, there is a number of defenses one can raise once they raise, once a cause of action has been laid down, like upon them. Someone can raise a defense of force of God. The things that happen, and you as a person, you do not have control over them. Mark you, like, even if you would have tried, there is nothing you would have done. This is something natural. You can look at something like, maybe, can I say flights? You got these people maybe to come and wire for you, your house. They have your permission and everything, and then the weather changes. Maybe floods come and, someone goes like that, or someone suffers the damage. It's not upon you. This is force of God. Then we can also have a defense of contributory negligence. When you talk about contributory negligence, this is yes, you have come to my premises, you have my permission, I owe you a duty of care, but then the damages you're suffering, you actually have a hand in it. You contribute to the damages you have suffered. For example, if you are to look at, I don't want to give an example of electricity again, it may seem dominant, but let me talk about national water. They come to fix for you water or to put up for you a tap or something like that, or a drainage or something, and then they have your permission. Yes, you owe them a duty of care, but then anything like happens to them, like during the course of their work, maybe out of negligence, maybe with their machines and what have you, they suffer damage. You can raise a defense of contributory negligence. However, that defense of contributory negligence does not it does not remove the liability from you. You simply share the damages, and in most cases what court does, it may not fully put it on you as the person who was owed the duty of care, but if this person comes in and they pray for damages, maybe it is so high, it is under the discretion of court. Court can mean to say that since you also contributed, you are part of this, it reduces the damages to suit the situation.
I can also supplement on contributory negligence. For contributory negligence, just as you are saying, contributor, you all contribute to the fault that later comes from the aftermath of contributory negligence.
It is that maxim is on voluntary assumption of risk.
Example, I have a swimming pool at my place. You visit me, then you ask for permission. May I please use your swimming pool? Then at that point, I tell you the swimming pool has a default. It is not good for using now. Then you're like, it's okay, I can manage. I'll say, and then whatsoever situation arises from there. So you go ahead and you do the swimming. anything that happens to you there. For example, probably it could be the what? It could be the metals that support the ladders when you enter into the swimming pool. Probably they are weak. Then all of a sudden, when you're trying to use it, it happens to injure you or whatever.
Yes, but that takes us again to consent. That may not thrive more under contributory negligence, it may thrive more under consent. If I inform you that there is a default, or if you get to know, you have my permission, but then you get to know that such and such a thing is faulty, and you go ahead to use that facility, and then you suffer damages or anything happens to you, it can be a defense for the person you are suing because you consent.
Okay. Consent is also a defense. Okay. And then they talked about contributory negligence. Contributory negligence does not exonerate, as my co-speaker said it, does not exonerate the defendant from liability, but then it mitigates damages. As in, if a person has been so deeply damaged by anything onto my land, probably, and he's also one of the reasons why that thing has happened, then it checks the damages. Yeah, if there are very many damages that were supposed to be given or awarded to the affected party, then it mitigates and maybe reduces because he has a hand or she has a hand. And another thing, as a defense, if a person would wish to set themselves free and innocent, they can raise a defense of voluntary assumption of risk. Yeah. Yes, the act has happened, the negligent act has happened, the tort has occurred, but then you voluntarily accepted it to take place. For instance, you come to my premises with my permission, and you sit under a tree, maybe a mango tree, and you very well know that mango trees release mangoes, and then the mango leaves the tree and hits your head.
In the season of harvest.
Yes, you voluntarily accepted to be hit by that mango by sitting under the tree. You get it? Then they talked about an act of God. Yes, an act of God can be a defense under occupiers liability. I invite you at my premises for a party, and while at the party, there come storms. They destroy the tent, and the tent hits your head. So where can I get control to control the storms? So you see, from the onset, it is an act of God, which can be a defense.
For example, in Rwanda, I mean, whoever got damaged, whoever was hit by the tent, you cannot begin suing the organizers or suing Chameleon himself, because it was an act of God. Yes. Storms simply came and everything happened.
Then warning is also a defense. Yeah, I've told you, do not use the other left gate. The left gate has dogs, but you've insisted on using the left gate. Probably you've been injured by the dogs, you've been bitten by the dogs, but after me warning you, do not use it, use the right gate, but you've insisted on the left gate. Then I can stand before court and tell them, my lord, I want the plaintiff, but he insisted on the left gate.
Yeah, okay. Thank you very much, ladies and gentlemen. I am so impressed and satisfied. I think you vividly discussed what occupiers liability is. I, for one, thank the Lord, and I've understood so much when it came to the defenses, because I know one day I may also be liable under the same. Now, right about now, I want us to move straight away to product liability. And I want to pose this question to you, the panelists. What is product liability? Give us a general overview of what product liability is.
Product liability, we are talking about defective goods.
Okay.
We're talking about injuries that are brought as a result of consuming defective goods or products. So this is where a claimant can have a cause of action against the manufacturer for putting out a poor quality good or unsafe good for human consumption, thus causing death and injuries, some sort of that kind.
Yeah. Mr. Moderator, product liability, as my co-speakers brought it, it is this liability that will arise by the virtue of defective products produced by you as the manufacturer. So this tort has got a root in one of the most celebrated cases, that is the snail case, which is literally called Donoghue versus Stevenson. This case laid down a principle that maybe establishes the foreseeability of damage when it comes to the products that are produced. So, as quickly to look through that case, the case of Donoghue versus Stevenson had parties whereby Mrs. Donoghue was bought for a beer. They bought for her a beer by a friend, and she consumed the beer halfway, and that beer was in an opaque bottle whereby you can't see anything inside. So as it was halfway, she happened to put the remaining into a glass, but on pouring into a glass there were decomposing snails. And now this brought a contemplation before court who should be sued on such a scenario, where the third party into this, that is the friend to Mrs. Donoghue, buying Mrs. Donoghue a bottle and buying it from a certain shop. And now, who should they sue? Should they sue the manufacturers? So we saw the manufacturers having a duty of care. In other words, a manufacturer has got to produce or manufacture things that are very good for public consumption. That is the principle that was in that case. So we saw the manufacturers of the beer, who are the Stevenson company, being held liable for the beer that was sold by one of their clients.
Maybe cheaply, I also want you to let the general public know. In the chain of supply, there are very many different stakeholders. There is the manufacturer, there is maybe a wholesaler, then there is a retailer, there is also a distributor. So, can all these categories of persons be sued? And if so, what are the preliminaries?
Okay. Under product liability, and giving our back and giving our strength and emphasis on the case of Donoghue versus Stevenson, we shall see that the manufacturers have a bigger thing to play when it comes to the effectiveness of the product. So it is really unfair to hold a supplier, to hold a retailer liable when the manufacturer is there. You get? So it really takes us back to the manufacturer. The manufacturer has a very big part to play when it comes to the consumer. They have to be so keen, and they must produce products that are worth or that are good and fit for consumption.
Okay. Maybe if I am to draw you to an analogy, for instance, if a distributor has supplied a certain product to a wholesaler, let me use beers, and these beers expire in the wholesaler's warehouse, and despite the expiry of the beers, the wholesaler still goes ahead to sell them to a retailer, maybe a bar owner, and this bar owner then sells the expired beer to a customer who is now consuming it and getting injury out of that expiry, who will still cover the liability of such an action.
Of course, those are some of the exceptions. To every general rule, there will be an exception. If someone has to keep this beer beyond the expiry date and then supply it, that means there is intention. I mean, for them, they are minding about the market. They are counting their losses and they don't want to lose. So it has to dawn to them. The manufacturer cannot be he cannot be held liable in this, because where is the defect starting from? It is starting from this person who kept the beers till they became defaulted.
Okay, thank you very much. So maybe as we wrap up, what are some of the defenses that could be available to a defendant in case they are sued for liability in this field we are discussing?
For product liability, because you have ascertained what it entails, that is, there must be a defect in the product,
Yes.
and of which it could be a manufacturing defect, it could be a design defect, it could also be a marketing defect. Okay? Then, now as a defense for someone who maybe would wish to exonerate themselves from liability, one can also raise a defense of contributory negligence. Yes, for example, I've manufactured a beer, all right? And then, yes, you see, there are always different terms to every commodity. You get? They sell your commodity and they tell you keep it at room temperature. You get? They say you do not maybe keep it near the fire, or they are like keep it in the freezer. You get? And for you to ignite that temperature, you take the commodity and then it turns out to be violent. I can say yes, I sold you a beer, I sold you something, but then you did not follow the precautionary. Yes.
And if I'm to bring in another example, if you're to look at, in most cases, the toxic products, for example, beers, wine, there will always be those precautions they put, like not to be sold below this age, maybe below the age of 18. And then maybe your child goes and buys for themselves, they suffer those damages. That can be raised as a defense because there is already a precaution. Don't sell this like below this age.
Maybe you can also raise a defense of limitation. When it comes to civil suits, there is always a limit, or there is a limit that has been set under the Limitation Act, that is Section 3 of the Limitation Act, whereby you cannot bring a suit beyond 6 years. For example, I've sold you a defected product, and then you keep quiet over the matter, and then you see after the 6 years, you bring up the suit. I will say you're limited by the statute. The law will limit you. So, in other words, if you find the defectiveness of the product, you report as possible. If you wait and then you're bad by time, probably we can maybe think it didn't turn out to be violent. So a limitation can also be a defense for someone, or even an act of a stranger. Yeah, I can sell you a product, and then maybe during the event of using it, another person maybe does something to it. Or you see, there are products whereby you need to mix before using. Then you buy a product, I buy a product, but then to the process of using it, other people tamper with it. And then it is maybe the actions of the person who has delivered it to me after me buying that has affected me. I can say maybe that person did not measure or did not follow the precautions that are surrounding that product. It could be an act of a stranger.
All right, thank you very much, our panelists. I must say it was indeed a fruitful discussion. I have learned a lot, and I hope everyone else outside there has learned a lot. This is a CMC law, and we urge you all, legal Puritans, students of the law, and all other people who are interested in legal matters to subscribe to our channel and watch our videos, follow our programs. We are always there, we are dedicated to reach out to you with all types and diverse legal topics. Thank you very much and have a blessed day.